Hello, everyone. Welcome to the fourth lecture in the landmark Judgments of the Supreme Court series. The case that we'll be talking about today is State of West Bengal versus Union of India, a 1962 judgment of the Supreme Court delivered by a six-judge bench split 5:1 with one dissent. And the reason why I picked this case as, in a way, a return to the lecture series is because this is a judgment that perhaps reflects in very clear terms the precise manner in which a constitution is a document about power. That is, who exercises power, how is power to be exercised, and what are the limits of the exercise of power. Now, last year, in the first three lectures of this series, when we talked about the A.K. Gopalan case and the V.G. Rao case and the S. Krishna case, we talked about one form of power, that is the coercive power that the state exercises over citizens, and how the Constitution does or does not seek to limit that kind of power. So when you think about preventive detention under Article 22, right to life and personal liberty under Article 21, or the various rights to free speech, association, assembly, and so on under Article 19, it's all about the limits of state power is exercised against individuals or groups, and when that kind of power can be exercised, when it can't, what the limits are, and what the role of the court is in those kinds of cases. But there is another kind of power that is equally important, if somewhat less talked about, and this is structural power, or power that is divided between the different representative organs themselves. So when we think about fundamental rights, we think about the vertical relationship between the individual and the state and how power flows along those vertical lines. In a case like this one, State of West Bengal versus Union of India, what we're talking about is the horizontal distribution of power between the different representative organs, different units of the federation. And while it may not immediately seem to possess the same kind of urgency or importance as the fundamental rights cases do, it is actually in its own way equally, if not more important, because the more that power is divided or distributed or decentralized, whether it's vertically or horizontally, the less there is concentration of power, and the less concentration there is, the more difficult it becomes to misuse or abuse power. And so even though the fundamental rights cases present the relationship between the individual and the state in very direct and stark terms, there is a range of cases involving horizontal distribution of power, involving federal questions, that whose effect on citizens' rights is as important, if a little more indirect. So that's, I think, it's important to keep that in mind when we think about this case, State of West Bengal versus Union of India, and the implications that it has. Now, this case is a case basically about federalism. And I think as all of you have learned in your constitutional law classes, India is an asymmetric federation. It is a federation where the constitutional structure is biased towards the center, reflected in a range of provisions from emergency powers to residuary powers and so on. And so there are a number of scholars who, analyzing federalism in India, have pointed out how it is skewed towards the center, and therefore it's not a true federation but a somewhat skewed one. And you'll see some of those debates and discussions reflected in this judgment. But the thing is that the way it's often taught is it stops over there, and very little is then discussed with respect to what the implications of this are, and more importantly, how should courts interpret or adjudicate federal questions given the asymmetric character of Indian federalism. And what you see in this case, State of West Bengal versus Union of India, is a very clear division between the majority and the dissent in what the implications of India's asymmetric federal structure are for courts when considering disputes between the various units of the federation. And one aspect that this case, I think, reflects very clearly is that the constitution is a terrain of struggle, in that there are always two or more solutions to a problem. And with respect to the federal structure, this case represents, in the majority and in the dissent, two very different answers to the problem of how a court should understand or interpret or adjudicate a dispute between the center on the one hand and the constituent units on the other. Being a very early case, 1962 is 12 years into the existence of the Constitution, and being a judgment of a 6-judge bench, of course, a case like State of West Bengal versus Union of India has in many ways set the tone for the direction the court would take in understanding and interpreting and adjudicating federal questions. And by the end of this lecture, I think that we'll be in a position to see what the direction is, and maybe ask ourselves if that is the right direction or if the dissent has actually got things right. So with that, what was this case about? The core issue in this case involved entry 42 of list 3 of the 7th schedule. So as you all know, the 7th schedule provides for the competence, it provides for the fields of legislation. So list 1 is the fields in which the center federal parliament can legislate. The list 2 is the list in which the state assemblies can legislate, and list 3 is the concurrent list. And of course, the executive power of both the union and the states is coextensive with legislative power, so that has those implications. So the core issue in this case was with respect to the interpretation of entry 42 of list 3, which basically talks about acquisitioning and requisitioning of property. And because entry 42 is in list 3, it's in concurrent list, so both the union and the states have the power to legislate for the acquisitioning and the requisitioning of property, and also to take executive action coextensive with the legislative power. Before entry 42, there were 3 different entries that dealt with basically acquisition and transfer of property. There was one in the union list, one in the state list, and one in the concurrent list. These 3 were repealed, and the composite entry 42 was then brought in to the Constitution. So in purported exercise of power under entry 42, there was the Coal Bearing Areas Act of 1957, not the act itself. There were other notifications that were under this entry, but just to lay the context. So there was the Coal Bearing Areas Act of 1957, and 2 notifications were passed under that the union traced back to entry 42. And through these notifications, the Union of India proposed to acquire certain coal-bearing areas situated in the state of West Bengal. So to put the matter simply, various areas, lands in West Bengal under which there was coal, and the Union of India wanted to acquire those lands in order to kind of promote and take forward the national coal policy, engage in mining and so on. The state of West Bengal opposed it on 2 principal grounds. One was that the Coal Bearing Areas Act of 1957 itself did not contemplate the taking over of property of the states by the union. So it was a straightforward argument that the executive notification, secondary legislation, was ultra vires the parent act. The second, and for our purposes more important argument, was that even if the act did so provide, it was beyond the competence of Parliament, the federal Parliament, central union Parliament, to pass that law. Now, at first blush, it's unclear why that would be so, because entry 42 is in the concurrent list. Entry 42 provides for the acquisitioning and requisitioning of property. And this is a case of acquisitioning and requisitioning of property under law and notifications. So the argument raised by the state of West Bengal, and in this it was supported by a number of other states. So when the case came before the Supreme Court issued notice to all the other states as well. Of course, the states back then were not as many as they are now. And all those states came before the court, represented by their advocates general, and most of them, barring one, supported West Bengal in various ways and to various degrees, and to basically make the argument that it was not open to the union to acquire state property without consent or an agreement of the state. the primary argument raised in that regard was that even though entry 42 of list 3 provides for acquisitioning and requisitioning of property, there is an implied limitation upon the scope of their entry. So the field of entry 42 is limited impliedly by the federal principle, and the federal principle is that in their respective domains, the union and the several states are sovereign. So if federalism means anything, it means that once power is divided between the constituent units of the federation, then in their respective domains, they act as sovereigns. And so with respect to the property of the states are sovereign. And so therefore, the power of acquisition or requisitioning of property is limited to acquisitioning or requisitioning property from private individuals or private corporations, private firms, but not the property of the states or of the union, because that is where the principle of sovereignty applies. So in effect, the text of entry 42 is unlimited, but the constitutional principle of federalism provides an implied limitation to to the scope of the field. Now, of course, the argument of implied limitation is something that is familiar to all of you, perhaps most vividly in the Keshwananda Bharati case, where arguably it was rejected by a 7-6 majority. And of course, this case was before Keshwananda Bharati. And in more recent times, those of you who have followed the Brexit cases in the UK would have seen that the UK Supreme Court in the Miller case articulated something quite like implied limitations when they said that when there are two constitutional principles, you have to interpret an act in a way that would not frustrate either of them. So those constitutional principles operate in implied limitations on the power of the executive and so on. So this is a kind of an argument to the venerable vintage. It's not, it's a familiar argument. So that was the primary, and of course there were a range of other arguments made by the state of West Bengal with respect to the fact, for example, that at that time there was still Article 31 of the Constitution, now repealed, which spoke about what to do when property was acquired by the union. And the phrase used in Article 31 was property of any person. And so the state of West Bengal argued that obviously the word person could not include states. That would not make sense. And then the state of West Bengal argued that, look, Article 31 provides for various safeguards that exist when the union seeks to acquire property or the state seeks to acquire property from any person. And so you're basically led to this absurd situation where an individual person has more safeguards when their property sought to be acquired, whereas a sovereign state has fewer safeguards if entry 42 was to be written in a way that would include acquisition of property of states themselves. And so there were a range of these textual, technical, statutory, interpretive arguments made by the state of West Bengal, but under the kind of overarching head that the federal principle required the court to place brakes on the power of the union to compulsorily acquire property of the states. Now, the court split 5-1, and majority of 5 rejected the argument of state of West Bengal, accepted the argument of the union, and held that the acquisition of the property of states was validly done under the Act and the notifications. So the majority began by noting that the Act was broadly worded. It spoke about land belonging to the state. And so therefore there was nothing in the text of the Act, the Coal Bearing Areas Act, that could justify any limitation upon the kind of power it granted to acquire property. And so then of course the argument wasn't that there was a textual limitation in the Act or a textual limitation in the Constitution. The argument was that the limitation is necessarily implied by constitutional principle. And so then the court went into understanding whether the constitutional principle of federalism was applicable, and if so, what it required. So here it's interesting to see that both the majority and the dissent, and we'll come to the dissent later, told a historical story, because you couldn't understand or analyze this case without having an understanding of the political and constitutional history of colonial India leading up to independence. And so what the majority noted was that historically, India, the Dominion back then, had always been a centralized polity. So right from 1858, when the first Government of India Act was passed, when power left the hands of the East India Company and was transferred to the British Crown, it was always a very centralized polity where the Governor General and Council, a figure that you all know of, ultimately had the deciding power for almost everything. And in that sense, it was effectively a unitary centralized colonial state. Over the years, starting with 1909 political reforms through 1919, 1935, various attempts were made to create representative institutions, specifically in the provinces. And this is a history that you are all familiar with. Montague-Chelmsford reforms, Morley-Minto reforms, and so on. But what remained constant nonetheless was the overriding power possessed by the Governor General. And so even when there were attempts to devolve and decentralize power, the ultimate repository of state power was nonetheless the Governor General. And the Government of India Act 1935 was an act that also, despite having various attempts and various mechanisms of devolving power, nonetheless retained that centralizing feature of various Indian constitutional instruments. And under the Government of India Act, there was a section 127, whereby the central government could compel a province to acquire land on its behalf. Now, the court seized upon this section 127, this provision, and said that, well, first of all, it was never considered that this provision unfairly infringed upon the autonomy of the provinces. And then the court said that, and if you now look at the Government of India Act 1935 and the Constitution of India, what you find is that between these two constitutional instruments, the basic structure, and in fact, the court uses the term basic structure, interestingly, the basic structure was never altered. The broad administrative outlines remained the same. And so in that way, what the Government of India Act did and how the Government of India Act 1935 was interpreted is a blueprint that can be used to interpret and understand the Constitution. And for that reason, given that under the Government of India Act, there seemed to be no real issue with respect to the central, the Dominion government compelling provinces to acquire property. Clearly, it was never felt that the power that the Union would have to acquire the property of states would create a problem for broader federalism and other similar concerns. That was the first historical argument the court made. And as you can see, it was dependent on a historical understanding that treated, that looked at the constitutional and political history of India from 1858 onwards as essentially a continuity that ended with the Indian Constitution of 1950, but all the instruments before that was in a sense leading up to that. And what was done under those instruments could be then taken as reflecting good practice or good principle. And then similarly, those principles could be used to interpret the Constitution as well. Having said that, the court then engaged in an articulation of what Indian federalism was about, or what exactly it meant when we say that India is a federation. And the court began with a classic argument that I'm sure all of you have heard multiple times, that is, there's a distinction between a federation where independent and sovereign states come together, agree to abdicate some of their sovereign power into a union and to retain the rest of the power to themselves. That, of course, is the American example. That was how the United States of America was created, by that time 13 states coming together and giving up their independence, part of their independence to the Union. So the court basically said that that's kind of a classic federation, but India is not a federation of that kind. And what the Indian story is that here at the time of independence, power was taken from the British Crown, given and it vested with the Indian people. And then from the people, it was distributed into like these various representative organs, unions, states, and so on. And so in that sense, India was never a federation where sovereign states came together to create the constituent union. Having said that, having told that historical story, the court then looked at a number of provisions in the Indian constitution that envisaged the superiority or the greater powers of the union over the states. So, for example, under the constitution, the union can take over national highways, ports, and so on, even though they lie within state territory. Article 356 is, of course, the classic example where the emergency powers, the government of a state can be dismissed if, in the opinion of the president acting on the advice of the Council of Ministers, it appears that the constitutional machinery in that state is not running in accordance with the provisions of the constitution. So there is that power. Under Schedule 7, residuary powers lie with the center, not with the states. Then there is the principle of repugnancy, whereby under Articles 252 onwards, so 254, whereby if there is a clash between central law and state law, if they operate in the same field, then to the extent of inconsistency, an extent of overlap, the central law will prevail. The court pointed out that in the Indian scheme, the states depend upon the union for finances. And this is something we don't often talk about. But if you look at the fiscal federalism provisions, you will find that the dependence is actually quite extreme. So, for example, under Article, if I remember correctly, 293 or 294, one of those articles, if a state owes a debt to the union, then the state cannot borrow or any money from any other source without prior permission from the union. And most states actually owe money to the union over the years. There is some kind of debt that exists. And so in that sense, the union can control how states can raise money. Because of course, sovereign borrowing is a fundamental way that sovereign states raise money. And so that in that way, in provisions like that, the center exercises a great amount of power over the fiscal freedom afforded to the states. Then, of course, you have Article 3, under which the federal parliament can basically, after only requiring consultation with the concerned state, can alter state boundaries, destroy a state, join two states together, the standard set of things in Article 3 that can be done. So the court basically recited all of these provisions of the Constitution, and then said, look, it's therefore very clear that under the Indian federal structure, overriding powers of all kinds lie with the union and with the federal parliament. So evidently, the power to acquisition or requisition property that would otherwise belong to the state is well in keeping with this idea of Indian federalism, where the union is dominant. So in that sense, there is nothing that is violating Indian federalism. If entry 42 was to be interpreted in a way, it would allow the union to acquire the property of the state. And then the court went on and said, in any case, entries 52 and 54 of list 1, that inter alia allow for regulation of mines and minerals that the union feels is in public interest, are also applicable. So, and the declaration had been made in this case that coal was a matter of national interest. And so you can even trace back the acquisition of property to entries 52 and 54 of list 1, and not just entry 42 of list 3. And finally, the court said that even Article 31, the word person can include state for the purpose of that article, and yes, the same sort of safeguards would apply if state property was acquired by the union. But Article 31 is not an escape route. So it's not that because Article 31 does not contemplate the property of states being taken, That therefore means that nowhere in the Constitution is there any contemplation that state property can't be taken, but Article 31 actually includes situations where the union may want to take state property. So having marshaled all of these arguments and putting them together, in sum, the majority basically held that there was nothing in the text of entry 42, list 3, or in the Coal Bearing Areas Act of 1957 that limited the power of the union government to take over properties that belong to the state of West Bengal. Given there was no express bar, there was also no implied limitation, because Indian federalism, or the federal structure, explicitly envisaged the dominance of the union over the states, as was reflected in this whole range of provisions. And therefore, reading into entry 42, or including within entry 42, acquisition of property that belonged to the state was clearly well within the broader and fitting within the broader constitutional scheme. And so therefore the majority held that based on all of this, the state of West Bengal had no case, and the property could validly be taken over by the union. So that's as far as the majority reasoning goes. And now we come to the dissent, and it's interesting because it's always interesting to read judgments where there is a majority and a dissent, because what the majority said so far might sound very persuasive, but when you see the dissent, you always see the other kind of reasoning. And then it gives you like a clear template to understand where the clashes are and what the arguments are. The dissent was authored by Justice Subba Rao, who was actually, I think as many of you would know, a very famous dissenter. So through the 60s, he was constantly dissenting in a whole range of cases, civil rights, federalism, and so on. And what you'll find about him is that his dissents, for the most part, used to push back against any kind of increase or concentration of power in the union executive, whether on the other side were people, states, or whatever. His concern was about limiting and preventing the concentration of power in a constitution that already had tendencies towards centralization. So I think, and that's why I think he's a really important judicial figure in our history, and his judgments really deserve careful study from this perspective. So what did Justice Subba Rao, what was his reasoning, what did he argue? So like the majority, he began by noting that, yes, indeed, if you look at the structure of the Indian Constitution, the states are in a very weak position with respect to the union, especially in financial matters. And he talks about, I think in prescient terms, he talks about how even though it's not always direct, there are many ways in which the union can exert indirect pressure on states to bring policy in line with the union wants by threatening to withhold funds and so on. And I think you may remember recently there was a controversy over how in the Electricity Act, the union was trying to smuggle in various conditions that the states would have to comply with if they wanted to access certain kinds of finances and so on. So basically the union essentially has the power to influence state policy by threatening to withhold funds or making borrowing conditional upon various conditionalities that then the states have to fulfill that actually are in the domain of policy. So Justice Subba Rao notes all of this. He notes that this is what's happening. And now if you think about it and just abstracting for a moment from the actual judgment, what are the implications that follow from the observation, the factual observation, that the Indian Constitution is sets up a federal structure that is biased towards the center? One possible conclusion is that therefore anything the center does goes because it is well within the domain or within the scope of Indian federalism. And so therefore the court's adjudicatory task is to facilitate the center encroaching or taking power, because the Indian Constitution's federal structure is biased towards the center. It envisages union supremacy over states. That is one implication that you may find from these set of facts. The other implication is that The Indian constitution, of course, is federal, whether what kind of federation it is federal. And given that it has provided for express provisions which grant more power to the union than they would exist in, say, a classic or old federation of the American style. I wouldn't say it's the main kind of example, but just say the old style federations like the US. Given that the Constitution already has provided for all those provisions where the union exercises greater power, it is the court's task to ensure that those limits are strictly maintained. So anything that goes beyond that express additional grant of power to the union has to actually be struck down and be limited, because that is what maintains the Constitution's federal structure. And so therefore, the very fact that you have all these provisions that give power to the union create imperative upon the court to ensure that in all other cases, any attempt by the union is repelled and interpretation goes in favor of the federal units. That's the other implication you can draw. And that indeed is the implication that Justice Subbarao draws from the very same constitutional structure that both he and the majority are faced with. So what he says is that what the Indian federal structure shows as per the Constitution is that you have the division of powers, and within each domain, the units are exclusive. They have exclusive power. And it is telling, Justice Subbarao says, that when extensive encroachments are allowed to the union under Article 356, it is specifically for an emergency. So it's only for an emergency situation where those kinds of powers can be exercised by the union. And so clearly in normal times, that is not what is meant to happen. And I think this is a very clear distinction between the emergency regime, which is meant to be isolated and kept separate from the normal regime, is a very important insight that Justice Subbarao gives in his judgment, and that's applicable beyond the simple domain of this case, but also applies to a range of other cases involving civil rights and so on. So he says that you need to put those provisions to one side because they are meant to do with emergencies. And then undertaking a study of various federations, he says that if you actually look at it, every federal constitution has some unitary elements. So even in the American Constitution, you have unitary elements. You have the Commerce Clause as interpreted by the court and so on. And looks at Australia, looks at Canada, a bunch of countries. And he says that all of these, in different styles and different ways, have unitary elements. So it's not that if your constitution has some unitary elements, such as in our case, national highways or fiscal dominance or so on, that doesn't vitiate the federal character of the constitution. All that matters is that what the core federal principle is whether there exists a division of powers. And according to that division of powers, the respective spheres within that are so divided are substantially independent in their own respective domains. So that's for him the core principle. And that is what is important to maintain, that the court's task is to gatekeep and to maintain the sanctity of that principle. So that for him is what federalism means, and what of specifically Indian federalism. And so here this I think perhaps the most fascinating part of the judgment, because he tells a very different story, a very different historical story of how federalism evolved and the need for it. So remember, the majority had said, look, India historically after 1858 colonial state was unitary. It was always skewed towards the center. States were never sovereign. And it's not a case of where sovereign states come together and form a union. So for all those reasons, this is just a continuation of that history. So Subbarao on the other hand says that doesn't matter. It doesn't matter for what reason the states came together, whether they were sovereign before or not. That story does not matter. What matters is why. What are the reasons why we have a federation? It's like a purposive understanding of the constitutional structure. So why is it that we have chosen this way of governing ourselves? And this is where he gives the answer. I'll quote from his judgment. He says that after saying it doesn't matter that what that history was, how they came together, he says, the pre-existing independent states may not be given any appreciable power under a constitution, while newly formed states may enjoy larger power under another constitution. So basically what he's saying is that, I mean, you could have a situation where you did have all these sovereign states who came together, but the final constitution gave them very little power. On the other hand, you could have a situation where states were created at the same time as the nation was. So it was basically like their creation is along with the nation. But nonetheless, they are given a lot of power under the constitution. So it doesn't matter why or what the reason was why it came together in that way. But why is it that it exists in that way is what matters. And then he says that a federal structure is mainly conceived to harmonize existing conflicting interests and to provide against future conflicts. India is a vast country. Indeed, it is described as a subcontinent. Historically, before the advent of the constitution, there were different provinces enjoying in practice a fair amount of autonomy, and there were innumerable states with varying forms of government ranging from pure autocracy to guided democracy. There were also differences in language, race, religion, etc. There were also foreign pockets expected sooner or later to be incorporated with the main country. In those circumstances, our constitution adopted a federal structure with a strong bias towards the center. Under such a structure, while the center remains strong to prevent the development of vociferous tendencies, the states are made practically autonomous in ordinary times. So again, the distinction between ordinary times and emergencies within the space allotted to them. So his story, therefore, is a story that federalism is required in order to harmonize the conflicting interests that come with any big entity with a plural and diverse heterogeneous population. And this is, of course, in political theory, a fundamental rationale for decentralization of power, the devolution of power. And here we come back to the whole idea of horizontally decentralizing power, not concentrating it, is that the closer the people are to government, the more viable it becomes, legitimacy becomes easier, administration becomes easier, and so on. So that is the reason why we have federations, not unitary states. That's the reason why power is devolved, to lower levels, why devolution happens, and so on. So that's the rationale that he hit upon for the Indian federal structure, subject to the fact that at the time of independence, there was a large effort made to unify the country, and there were, according to him, fears that it might split apart. And so the dominance or the bias towards the center that is present in the constitutional structure is due to the fears of the framers that in what he calls vociferous tendencies would exist. And so therefore, to hold the union together, you would have to grant a certain kind of set of powers to the center that would result in a bias in the federal structure. But it follows from that, therefore, that when you're looking at interpreting or interpretation as a court, then the bias you accord to the center has to be limited to the purposes for which that bias exists, which in Justice Subbarao's view is to ensure political unity and to prevent, say, the breaking up of the country. But in all other cases, you have to respect the core federal principle, which is that the separate constituent units of the federation have to be given full leeway and full latitude in their respective domains and spaces. So you can therefore see how his historical story is different. He's not even disagreeing with the majority's historical argument, which is the evolution of centralism in Indian colonial history and independence. He's not disagreeing with those facts. He's just saying that those facts don't matter. What matters is why does our constitution have what it does? And when you look at that, then a different answer emerges. And a different answer is that there is no reason why a court should seek to further entrench the already existing bias towards the center in the constitution, unless the case involves one of the political, unity or the political structure of the country. And in all other cases, in fact, the court should seek to advance the federal principle, which is that the different units have independence in their respective domains. So that you can therefore see that is where the core distinction is between the dissent of S.S. Subba Rao and the majority opinion, and their respective conclusions flow from what they understand Indian federalism to be about and what they think is relevant in the historical story that led up to the creation of the Indian federal structure. Now, Justice Subba Rao goes on to discuss all the other arguments that we have talked about. He talks about how eminent domain as the power of the state to acquire property only can apply to private property. It cannot apply to states who are sovereign in their own domains. Of course, that was the argument the majority rejected. Majority said that you cannot think of the states as being sovereign in any meaningful sense. He looks at Article 31. He says, look, there's no way that person can include the state. And it's very clear Article 31 was never meant for the union to take property of the state. And that also clearly shows the Constitution doesn't envisage a mechanism by which that can happen. He looks at the Government of India Act. He says that, look, under the Government of India Act, a transfer of property between the state and the union could only happen either with permission or under an arbitral award, under an agreement. And Article 298 of the Indian Constitution reflects that principle. And so that has to be given its full understanding. He talks about how residuary powers, that is, residuary powers of the center, cannot go beyond the existing distribution within the lists. And so you can't say that, okay, fine, entry 42 does not allow the union to acquire property of the state, but the residuary powers do. So you can't say that because there is a clear division of powers in explicit terms under Schedule 7 that specifies what the respective domains are. And so residuary powers can't be used then to override clear division of fields of legislation. And lastly, he says that that under entry 52 and 54, it's only that what you're allowed to do, what the union is allowed to do, is to regulate mines and minerals, for example, in the national interest. It doesn't necessarily mean that the power of regulation must also extend to the power to acquire property. And of course, that comes up against the implied limitation you find under entry 42, which is that the power of the union to acquire property and requisition property stops at the point at which that property belongs to a state, a constituent unit of the federation. That's how he deals with these arguments, and of course takes a different view. And these are all, I think, arguments where you can agree or disagree with the majority and Justice Subba Rao, and it's worth reading the judgment closely to see where you stand. But as I said, the main clash there between the two is an understanding of when you're looking at this constitution with its federal structure that is biased towards the center, how do you understand this? How do you interpret this? And what is the historical story you're telling with respect to why this structure exists? And because they differ on that historical story, they differ on interpretation of the Constitution, and therefore they differ on their outcomes in this case. As Subba Rao's basic thrust of his argument is that the court should not curtail the already limited power of the states even further. Right? So already you're limiting their power. And so therefore, whenever there is a constitutional silence or a constitutional ambiguity or a constitutional gap, then the federal principle, as understood by Justice Subba Rao, requires you to interpret in favor of the states and not the center. There's one other point of difference I want to just briefly mention. I think it's important, again, is broadly a principle of constitutional interpretation. So an argument was made that if this case was to be decided in favor of the center, then effectively the center could bring the machinery of administration in the state to a complete halt, and it could take over government buildings, could take over everything that is required to run a state government, and therefore, for all practical purposes, bring state administration to a halt. Now, when this argument was raised before the majority dismissed it by saying that, look, I mean, and this is again an argument that you would all have heard, it's a famous argument, that the potential for abuse is no ground to strike down a law for being unconstitutional. And these are all cases where, yes, there might be potential abuse, but, you know, that is not a reason to strike down the law. And that when there is abuse come before us, but, you know, we can't strike down law for that reason. And of course, this framing that possibility of abuse is no ground to strike down the law is framing that you all know about. Mr. Subbarao takes a different view, because what he says, and this is really important, he says, actually, look, it's not abuse. This is actually use, right? So if we interpret our entry 42 as allowing the union to acquisition or acquisition property of a state, and then, for example, if the union does acquire, you know, Vidhan Sabha or like acquires government buildings and so on, that isn't abusing of power. That is literally the union acting within the exact boundaries of Entry 42 as interpreted by this court. So it would be a classic case of just being well within constitutional bounds. So where is the abuse here? And then he says that actually what the constitutional principle is that if interpreting a provision of the Constitution allows for this kind of an outcome, which would enable the union to completely destroy the federal balance of powers, then that's an interpretation that the court shouldn't give to the Constitution, because the Constitution is meant ultimately to be a federal constitution, right? So the court's task is to ensure that its interpretation of these provisions is one that doesn't then enable the union acting within and consistent with their interpretation to do things that will destroy the federal balance altogether, right? And so that's kind of this really crucial distinction that between abuse of power and the argument that abuse of power is not a ground for the power to not exist on the one hand, which is what the majority sees it at, and on the other hand, the argument that use of power stops at a point at which that use would destroy a constitutional principle, in this case federalism, and therefore when the court is interpreting a provision, it has to ensure that its use, and not abuse, but use, cannot go to that extent. And in this case, the only way of ensuring that is to interpret Entry 42 in a way that excludes acquisition of the property of the states by the center. Justice Subbarao's judgment finally in the conclusion is something I think that is really sums up the argument. So I'll just read that out. So he says, this is the concluding. To conclude, the Indian Constitution accepts the federal concept and distributes the sovereign powers between the coordinate constitutional entities, namely the union and the states. This concept implies that one cannot encroach upon the governmental functions or instrumentalities of the other unless the Constitution expressly provides for such interference. The legislative fields allotted to the units cover subjects for legislation, and they do not deal with the relationship between the two coordinate units functioning in their allotted fields. This is regulated by other provisions of the Constitution, and there is no provision which enables one unit to take away the property of another except by agreement. The future stability of our vast country, with its unity and diversity, depends upon the strict adherence of the federal principle, which the fathers of our Constitution have so wisely and foresightedly incorporated therein. This court has the constitutional power and the correlative duty, a difficult and delicate one, to prevent encroachment, either overtly or covertly, by the union of the state field or vice versa, and thus maintain the balance of the federation. The present is a typical case where the court should stop the union from overstepping its boundary and trespassing into the state's field. I would therefore hold that the impugned act, insofar as it confers a power on the union to acquire the lands owned by the state, including coal mines and coal-bearing lands, is ultra-vires. That's his conclusion. And so I think that really kind of encapsulates very clearly what the federal argument is, whereas the majority's reasoning, as I've said, is a more central argument, in the sense that what they say is that the existing bias of the Constitution towards the center requires the court to interpret and provide more leeway to the center when dealing with its powers than it would in a more classical or old style federation. So I think that therefore this case is really interesting because it gives you two different views. It gives you two different stories about the Indian Constitution. And of course, as we know, one story prevailed and one did not. That is how it works. And it's worth thinking about what might have been different in Indian history had Justice Subbarao been the majority and not the dissent. And what we think about federalism and interpreting the Indian Constitution, and what our views are about that federal balance that he was so concerned about, and whether the historical record of the last 50 odd years, which is since this judgment was decided, what has time said? Has time proven the majority right, or has it proven Mr. Subbarao right? And if time has shown that the dissent was right, then maybe we should start rethinking about how we interpret the Constitution in the context of federalism cases. So with those thoughts, I will end and thank you all for listening and see you again next month. Thank you.